the terrible lighting in my room. I do the best I can. Um, Thanks for tuning in. It's Christine Van Gyn. I'm the litigation director with the Canadian Constitution Foundation, which is a legal charity that fights for fundamental freedoms in Canada. And I'm in Ottawa. I've been here all week attending the Public Order Emergency Commission, also known as the Rouleau Commission, which is looking into the federal government's decision to invoke the Emergencies Act in response to the 2022 Freedom Convoy. We at the Canadian Constitution Foundation are a party to this inquiry, which means that we are cross examining witnesses. And you can see videos of those cross examinations on my channel. If you subscribe, you can look up some of those videos. I haven't posted the videos of today's cross examinations yet because I just got back to my hotel. This video today on November 24th is going to be a summary of the witnesses we heard today. We heard first from Minister Chrystia Freeland. She's the Minister of Finance and Deputy Prime Minister. And then we heard from a panel of staff from the Prime Minister's office. Their names are Katie Telford, Brian Clow, and John Broadhead. So let's start off with Minister Freeland, the Deputy Prime Minister and Minister of Finance. She started off her evidence today with a really long and uninterrupted monologue of about 13 minutes of the importance of electric vehicles and about the Russia-Ukraine conflict, because she said she was dealing with that in the early days of the convoy. This used up a lot of the inquiry's precious time. I think it was a lot of political posturing. It's frankly irrelevant to the purposes of the inquiry. And, whatever your opinion on the value of electric vehicle subsidies, it sounds like it was an important trade matter at the time that she was negotiating with the US. And I actually sympathize and agree with her concerns related to the Russia-Ukraine conflict, but it is just absolutely not at all what we are here to talk about at this inquiry. And given the limited resources and time and energy we have, spending 13 minutes talking about that was awful, and I think that she should have been redirected. So after she finished with that, she testified that she started getting engaged on the convoy issue around the second weekend of protests in Ottawa because she had been focused up until then on these other issues that she talked about in her opening monologue. Commission counsel pulled up a memo on what were called options that the finance department had produced on February 9th, and it included two options. First, amendments to proceeds of crime legislation, and second, amendments to the Bank Act. Remember, Minister Freeland's real relevance here is because she was the one responsible for the economic measures that were promulgated under the Emergencies Act. These were the measures that froze assets for people associated with the Freedom Convoy. This was something that was done without a court order, which would normally be required, a big violation of Section 8 charter right to be free from unreasonable search and seizure. Is something that we have been very concerned with. And so that's a lot of what her testimony had to do with, about these economic measures. So she concluded that these options about amending the proceeds of crime legislation or amending the Bank Act, she said that on the first, the government had already been contemplating some changes to FinTrack for a while before the convoy started, since they viewed that, which is like financial monitoring agency, as outdated. With respect to the Bank Act, Freeland testified that they were looking at how the Bank Act could be used or amended to freeze accounts and what existing authorities existed that would have allowed them to do that. But she concluded that the legislative path takes too long, and in order to freeze accounts using a legislative path, they would not have had time. It takes 2 weeks, she said, at a minimum, when there's consent across the parties. And she said that the legislative timeline just wasn't appropriate to the size and scale of the damage she really focused on the border blockades. She also testified about a phone call that she had with President Biden's top economic advisor. She said it's normally really hard to get this advisor on the phone, but she was able to get him on the phone right away, which she said is indicative of how seriously the United States government was taking the border blockade issue. And she said he was very, very, very worried because the blockades were interrupting trade, especially at the Ambassador Bridge. And he was worried about the integrated US Canadian economies, especially in the auto manufacturing sector. And she said what really concerned her was that he didn't view this integration as a positive thing. And that's concerning because we don't want to encourage trade protectionism in the United States. She testified that the period of the border blockades was, to quote her, a dangerous month for Canada, and it was causing potentially what she called irreparable harm to our trading relationship, not just with the US, but potentially other countries as well, because a lot of countries will invest in Canada because of our trading relationship with the United States. She testified that the government had to find a way to bring the convoy, to an end. She was also shown a text message she'd received from the head of Stelco, which is a steel mill located in Hamilton, Ontario. And the head of Stelco asked her to consider ending health measures, saying, to quote this text message from Stelco, they don't seem to be effective anyway, especially relative to Omicron, and because they were compromising trade and only reinforcing American desire to onshore. Freeland responded that the relevant part of the message for her was the part about trade, not the health measures, which she said she did not want to debate with him. She was taken. So I just wonder what you guys think of that, since the government was clearly so unwilling to have a conversation with a lot of people in the protest movement who objected to these health measures as well. I guess she was willing to listen to the head of Stelco, but not engage with him on that particular issue. So I guess take that for what you will. Maybe the government will listen to you if you have a steel mill. She was also asked about a call she had with the bank CEOs on February 13th. Notes in advance of that call say that privately, TD Bank, CIBC, and Scotia had said that it may be worth looking into bringing crowdfunding platforms under anti-money laundering and proceeds of crime laws. And then on the bank call itself, Freeland said, quote, "This is an attack on democracy." When asked about this, she said she was responding to a bank telling her that they had frozen an account on their own under regulations that were processes within the bank that were automatically triggered um, related to anti-money laundering rules, and that was before the Emergencies Act was invoked. So she testified she said this because she was worried about the banks being blamed for what she said was, to quote, doing the right thing. So her attack on democracy comment, she said, was in response to that. One bank CEO, who she didn't identify, said that the government needed to consider bringing in the military to secure the border. This gives me some flashbacks to the testimony we heard yesterday from Minister Lametti and Minister Mendocino saying we should consider whether or not to engage the armed forces, and even joking about bringing in tanks to Ottawa, which obviously this is deeply troubling since military is trained in combat and they should never be deployed against the civilian population because of a public demonstration. But instead of shutting down this comment about we should consider bringing in the military, Freeland said, "I couldn't agree more." So Commission Counsel asked her to explain that. Were you considering asking for the military? And she said she wasn't really agreeing with his comments about the military. She was just agreeing that we need to resolve the situation. So I don't know what that means about what politicians mean when they say they agree with you, because certainly she says she was not agreeing even though that's what she said. She said, "I couldn't agree more," but in fact, that meant she did not agree. Okay. On that call, the bank call, Freeland also said, "We won't negotiate with the protesters," which, in my opinion, is really absurd. There are many opportunities to de escalate that situation, and any situation. Negotiation is an important part of law enforcement. It's always used, it's part of police negotiations, and police negotiators were used throughout the convoy. Indeed, part of the whole problem coming out of the evidence that we've seen so far is Ottawa's failure to properly use their negotiating teams, which were actually used pretty successfully at some of the border sites. So Freeland was asked about this. We won't negotiate. And her response today, while testifying, was, "We won't negotiate at gunpoint." So I'm guess let me know what guns she's talking about. I know that there was the incident of guns at Coots, which obviously is terrible, and it was the people involved have criminal charges associated with them. But I don't know what she's talking about. We won't negotiate at gunpoint with the protesters in Ottawa. It's just a really ridiculous statement, in my opinion. It's a little bit hysterical. And Freeland said her comment about not negotiating wasn't about tactics necessarily, but rather she didn't want to engage with negotiation about the possibility of changing any of the health policies. After the break, Commission Counsel brought up the issue of foreign funding, and she was asked if it was true that the government didn't actually have any information about foreign funding, because that has come up, that they didn't actually have any evidence that there was foreign funding before they invoked the Emergencies Act. She said that isn't quite true. Rather, the protests showed that the government knows very little about crowdfunding, and she said the government knew foreign funding of the convoy was happening, but the systems were weak at picking it up. She also testified, "We were operating in the fog of war, and we had to operate on the best information we had at the time, and that included open source information, not just information from official sources." So not only is this really dramatic, this fog of war, but it's also really troubling. It means that they were basing these economic measures that froze people's bank accounts on anecdotal information and open source news reports like things from the CBC. Freeland replied that she was comfortable with that and that was the right thing to do. She was presented by Commission Counsel with the draft of the Section 58 explanation. Remember, this is the legally required document that the government is required to table at Parliament, explaining the factual basis upon which they have relied in order to invoke the Emergencies Act. It's a document that also came up yesterday in Minister Lametti's cross-examination, where he claimed privilege over the factual grounds on which the government concluded there was a national emergency. The only explanation we get in that document, the Section 58 document, is a conclusory statement that an emergency existed, which is obviously circular. You can't say an emergency existed because an emergency existed. So we have argued that that is not good enough. But we saw today a draft of the Section 58 document, and Commission Counsel pointed out a heading in the draft version that had been removed in the final version. And the draft version said, to quote, "There was credible evidence of foreign funding." And underneath this bullet point, it said there was anecdotal information. So Freeland was asked why this was removed from the final version. And she said that this was a law enforcement issue and she wasn't involved in drafting the document. But I would say anecdotal evidence is not what I would call credible. Commission Counsel then moved on to the economic measures themselves, and Minister Freeland was asked if she was concerned that the economic measures were overly broad because they could affect joint accounts for families and also had the potential to affect mere donors. And we have heard evidence from uh, protesters who testified that joint bank accounts were frozen, that people who had their bank accounts were unable to get medicine, including medicine for a child. So that was obviously a big problem. So this was put to her. She replied that she didn't want anyone to get hurt, but something had to be done. She said, in what I think was one of her most dramatic comments of the day, and that is a high bar for this minister, she said, a colleague had told her, "My biggest nightmare was blood on the face of a child." And Freeland said that this blood on the face of a child image also really worried her. And she needed the protests to end peacefully, and that there were kids at the protests, and she didn't want anyone to be physically hurt. So, this concern about the blood on the face of a child shaped the development of the financial measures. And she said, in hindsight, the benefit of the measures, the economic measures, was that there was no blood on the face of a child. There was no physical harm. and she called the economic measures virtual tow trucks. She said she was concerned also about the number of people who were what she called restricted by the financial measures. But even though she was concerned about how their rights were implicated, this was balanced against the hundreds of thousands of people the government was protecting. She said in the end, there were about 280 accounts that were frozen. And while she doesn't know the individual number of people, remember, people can have multiple accounts and all the accounts they have could be frozen. So she doesn't know the final number of people, but she said by the time they'd reached freezing about 240 accounts, the impact was on something like 57 people, but she's not 100% sure the final number. So she testified while she regretted that this happened, she had to balance this with the people whose government, the people who the government was protecting, including protecting their jobs. And so while I hear Minister Freeland talking about protecting people's jobs, obviously I also share the concern of protecting Canadian jobs. But I thought a lot about the people who have lost their jobs over the past 2 years because of government shutdowns and policies. And it's interesting the government has this concern over jobs now, which they should have. They should be concerned about Canadian jobs being impacted by border blockades. But it's a concern that they didn't have when their own policies were causing a lot of Canadians to lose jobs. So Minister Freeland also testified it would have been great if joint accounts, in that situation, only the person who was protesting was restricted. And like say if their husband or wife was at home, that their husband or wife didn't lose access to the account. But she said that that is not technically possible. She said that the idea of freezing accounts was to create a non-violent incentive, and that the ideal outcome for her would have been to announce the measures and then never have to actually use them because everyone left voluntarily. She said that the measures were not meant to be punitive. She was also asked by Commission Counsel if small donors, like donors of small value amounts, like $25 or something, if they were captured by the economic measures. Remember, Michael Sabia, who's the Deputy Minister of Finance, has testified that they were not. They were not frozen. And the RCMP has also said that they were not. But Commission Counsel pulled up a text from Minister Freeland's Deputy Communications where he was quoting Freeland to another colleague saying that she was skeptical that small donors didn't have their accounts frozen because after all, the actual measures would have permitted this. So in this text, her deputy or her director of communications said, Freeland thinks the banks will have frozen smaller accounts and we just don't know. So Freeland was asked about this and she said that she was just being conservative and cautious. She said it was hard to comment though because she didn't write this text. It was not to her or from her. But the point that was being conveyed was that she didn't want to make a blanket statement that no single small donor was frozen because she didn't know for sure. And although she thought at that time the small donor accounts would not be frozen, and she hoped that was true, she didn't know for sure. And she said in the end, the outcome was that no small donor accounts were frozen. She was then asked about the necessity of the financial measures. By the time the economic measures had been implemented, there were a number of things that had already happened. So what the Commission Counsel is getting at was, were these measures actually necessary or did you exhaust all your other legal tools? Because at that point, the GoFundMe page had been shut down. By February 10th, TD had frozen a number of accounts using anti-money laundering procedures. Ontario had obtained a restraint order at that point, and there was a Mariva injunction in process, which ultimately it was obtained on the 17th, but it was in process before that. And the government knew all this. So why were the economic measures necessary? Why weren't these other tools enough? And Freeland replied that now they have hindsight, but they were looking back now at this one moment frozen in time. But in the real-time process, Freeland said the government's preference was for the other measures to stop the blockages, the border blockades, and stop the protest without needing to use the Emergencies Act, which she said is a measure of last resort. So that is not really an answer to the question, but that's what she said. Freeland also said that the banks were clear to her that they thought the existing measures were not enough. And that is consistent, she said, with her experience in the financial system, with it moving faster than the legislative system. And she said banks also raised concerns that when they acted to freeze accounts, they were being seen as taking a political position. And Freeland said that it should be the government wearing that political position, not the banks. She was also shown a text message by Commission counsel from former Minister Beattie, who is the author of the Emergencies Act. And this is the minister whose Hansard transcripts we actually pulled up yesterday and put to Minister Lametti. In a text from Beattie, he raised with Freeland the possibility that other measures could obviate the need for the Emergencies Act. Freeland said, by what he means by this, we would need to ask Beattie himself, and that he's very thoughtful, so the commission should consider interviewing him. Well, if he's very thoughtful and she thinks highly of him, why didn't she ask what he meant at the time when he said other measures could have obviated the need for the Emergencies Act? I don't know. Then the commission pulled up a handwritten note from a conversation between Minister Freeland and former Prime Minister Brian Mulroney. In that call, Mulroney said that these were handwritten notes by Freeland, and she wrote down him saying, "The thing is, the protests have stopped." So, asked about this, she said she doesn't really remember this part of that conversation because mostly what they were talking about was Ukraine. Now, the next thing the commission pulled up was that Section 58 explanation that I talked about earlier. And in that document, the Section 58 document, it talks a lot about economic security. And the commission counsel asked Freeland, and this was a big part of her testimony, what is the link between national security and economic security? And Freeland went into full politician mode. She said there are two links. First, she said our security is built on economic security, both as a country and for individuals. And she said many people could have lost their jobs from the border blockages. Again, this sudden concern for job losses, even though the government wasn't concerned over the last 2 years. And second, Minister Freeland said while blockages were going on, border blockades, many Canadians felt like their security was being undermined and Canadians were getting angry. And she said she worried about violence erupting between protesters and counter protesters. And she said it felt like a powder keg. She said this speaks to economic security because the economic challenge of the blockades made Canadians very angry. We ended up picking up on this issue in cross-examination because obviously to invoke an emergency, you need to meet the threshold in the Emergencies Act. And there is no such thing as an economic emergency. And certainly it is not, there's no economic emergency under the public order definition which the government relied on here. So the notion that Minister Freeland is saying there was a national emergency because of this economic emergency, well, imagine the number of circumstances where that could be claimed by any government, including a government you might, if you're defending the Emergencies Act today, imagine how this could be used by a government in the future, claiming there's an economic emergency to shut down, a general strike or something like this if you're on a different part of the political spectrum. I mean, people need to think through how the arguments that they're making to defend this could be used against them by a political leader they might not agree with. And I do not think that Freeland has thought through how changing the definition of emergency to include under a public order emergency to include an economic crisis, how that could be used against her in the future. So we brought this up in cross-examination, this notion that a threat to the security of Canada is a threat to national to our economy. And our lawyer, Janani Shanmugathan, took Freeland to the definition of threat to national security in the Emergencies Act. And that, of course, leads us to the CSIS Act and specifically to Section C. The definition says activities within or relating to Canada directed toward or in support of the threat or use of acts of serious violence against persons or property for the purpose of achieving political, religious, or ideological objectives within Canada or a foreign state. So that's the definition that Minister Freeland has said, an economic emergency was one of those things. So Janani asked, would Minister Freeland again agree that economic threats don't fall into that definition? Minister Freeland tried to predict the question. She replied, if you're asking if we were acting within the authority of the Emergencies Act, she said she believes they were, and if they didn't think they were, they wouldn't have used the act. Jennedy responded to attempt to refocus the minister on the question whether or not economic harm falls within that definition of national security threat. And again, Minister Freeland tried to evade answering. She said she was trying to be respectful, but it's a big question. It's actually not. And that she'd need to answer it in stages. She said one thing this commission is looking at is if the government was acting within its authority, but she's not a lawyer and she has relied on expert legal advice. Again, mentioning that they received legal advice. This is important for later, including for a cross-examination of the PMO council panel. It's advice. This legal advice is something we don't have access to and which we've asked for. We think that the government needs to disclose their legal advice they received on this. She said she was confident. Freeland said she was confident that it was the right decision to invoke the Emergencies Act, and she can also speak to what she saw and believed about violence, but she's not speaking as a lawyer because she isn't one. She said she has a real concern that we were in a tinderbox, to quote her, where the economic and general threats risked some kind of conflict between protesters and counter-protesters. And she said she was further influenced by the February 12th Incident Response Group meeting, that's a subcommittee of cabinet, about the presence of weapons in Coots, and so she was worried about copycats. To try to clarify this word salad, Jennany asked, so you think the definition under C of national security threat was met because economic harm could have manifested into physical harm and violence? Even though I do think that that's what the minister was trying to say, Minister Freeland said, no, that's not a fair characterization. So I really am not sure at this point how she's linking violence to economic harm if that was not what she meant. So she said what she really means is just that she relied on expert legal judgment to make a weighty decision. And when she was in Ottawa, she saw the potential for violence and that there was also economic harm. So she was asked again, do you see a link between economic harm and the legal definition in the CSIS Act? And at this point, the government of Canada objected. When the government of Canada was up later, they clarified her comments about this legal opinion she'd received, that it was not any intention to waive privilege, and that she does not have authority to waive privilege. The cross-examination from the convoy organizers, so I'm not doing this necessarily in order, I'm sort of doing it as different parts of the testimony relate to each other. So the convoy organizers also did a cross-examination that had some interesting bits. There were some questions about whether the vaccines are incentives or if they are health measures, which I think isn't necessarily relevant for the purpose of this inquiry, although it's otherwise an interesting question. And there were also some questions about the vaccine compensation fund, which I also don't think is relevant, but it's interesting. And she gave another long answer to convoy counsel Brennan Miller, and then he accused her of trying to talk out the clock, which I do think she did a lot of today, and I wish the commission counsel had made that observation and redirected her as well. There was a line of questioning from convoy counsel that turned out to be, I think, a little bit of a dud in the end. I thought it was interesting at first. It was about some notes in handwritten notes by Freeland that said designate them as terrorists in relation to designate the protesters as terrorists. So it started by asking Miller asking whether Freeland knew the names of the convoy organizers. She confirmed that she knew the names Tamara Leach and Chris Barber. And then she was asked if she thinks Tamara Leach is a terrorist. And Freeland said designating people as a terrorist is not part of her job. Intelligence agencies do that. So then he pulled up those handwritten notes that said from someone named David that said we need to designate the group as terrorists. At the time of the questioning, it was not clear who Dave was, but Minister Freeland confirmed it was not Dave Vigneault from CSIS. And then going through the notes later, it looks like this was actually a suggestion from a bank CEO, actually two bank CEOs. It looked like they wanted the protesters designated as terrorists, but we actually never got to hear Freeland's response to them saying this. We don't know how Freeland reacted to the bank CEO saying this. And obviously no one was designated as a terrorist, and this isn't Freeland speaking, it was her listening. So I mean, I would have liked to know how she responded to that, but we don't know the answer. And I think that these questions, to be honest, could have been a little better prepared, since going through them, it was more obvious who had actually said this. Convoy Council also asked Minister Freeland about her comments that the Terry Fox statue had been, to quote Freeland, desecrated by protesters. Now, if you'll remember, some protesters had put a hat on the statue and put an upside down flag in his hand and a sign on him that said "and the mandates." Now, whether or not you want to characterize that as a desecration or not, it's a matter of your own opinion, I think. But those were the words that Minister Freeland used. Counsel for the convoy asked her if someone put flowers on Terry Fox and a pride flag in his hands, would that be a desecration? And Freeland couldn't answer. And when she couldn't answer, counsel for the convoy asked, is it only a desecration when you disagree with the message? Which again, she could not answer. Now, there was a really excellent cross-examination by the Canadian Civil Liberties Association, which was done by Eva Krajewska. When the cross-examination started out, Minister Freeland said her preference is always to be on the same side as the Canadian Civil Liberties Association. And I guess in this instance, she is definitely not. So Eva asked if Minister Freeland agreed that the Emergencies Act should not be used to stop political disagreement. When Minister Freeland paused, Eva said, this is a very low bar. And so then at that point, Minister Freeland agreed. Eva asked if civil disobedience will sometimes cause economic harm or disruption. For example, in the case of a general strike. Minister Freeland objected to equating a general strike with the border blockades. And Eva said, okay, what about protests like Occupy Wall Street or Indigenous rail blockades? Those also cause economic damage. Freeland dismissed this and said that the economic damage done by those are very limited compared to border blockades. So Eva gave an example of port workers blockading a port in Poland, and I think that this was part of a general strike, which was cheered on by Western democracies, Eva said. Minister Freeland said she had thought about that, and she thought about the Maidan in Ukraine, and she said that these were protests against illegitimate authoritarian governments. This did get a bit of a reaction from the crowd of protesters in the audience, who I think some of them view Prime Minister Trudeau in the same way. I do not agree with that, but there was a crowd reaction to that comment. I do think that the Prime Minister is, legitimately elected Prime Minister. So that perspective I do not share, and I do not endorse, and I think is a bit silly. Minister Freeland said the situation in Canada isn't comparable to Poland and Ukraine because the government here was also enacting policies just after getting a new mandate following re-election. So Eva pushed back, saying, obviously, Minister Freeland, you're not saying that democracy only happens at the ballot box. It also happens in protests, and people can protest the government anytime, including just after an election. And Minister Freeland said, yes, but there's a big difference between the acts of resistance to authoritarian regimes and blockades in democracy. So Eva then brought up Russian President Vladimir Putin, who Minister Freeland had mentioned a number of times in her testimony today. Putin has made all kinds of pronouncements and comments that it's a good idea to invest in Russia or other authoritarian states because authoritarian regimes are politically stable and they don't tolerate dissent or disruptions. Eva asked Minister Freeland, you'd agree that economic security, the type talked about by Putin, doesn't trump democracy, right? And Minister Freeland replied that the government's intention was not to stop political debate, which is a sign of a healthy democracy. But she said our trade was being blocked blocked, and this was handing arguments to U.S. trade protectionists. Eva closed by asking Minister Freeland about her comments that it would have been acceptable to protest in a park. Um, but wouldn't she agree? Wouldn't Minister Freeland agree that the right to protest encompasses more than standing on a patch of grass with a sign? And Minister Freeland resisted, saying she's not trying to draw the line right here with us in the inquiry, but she does agree that in a democracy we need to protect the right to protest. That much is obvious. Frankly, I think that in this cross-examination, Minister Freeland was out of her depth. There was also cross-examination by the government of Alberta, where the lawyer for Alberta asked Minister Freeland if freezing accounts was better than using existing legal tools, which police at this inquiry have confirmed were available. There's been a number of policing experts and witnesses who have confirmed that there were other tools available. Freeland went back again to the point that kids were present at the protests and that these financial tools were peaceful and they worked. The lawyer for Alberta asked, but you would have known that there was a peaceful resolution at Coutts and Ambassador, the most serious blockades, before the Emergencies Act was invoked. Minister Freeland responded that she thought the financial tools helped the resolution of all blockades. There was still a blockade at Emerson, I think, after the Emergencies Act was invoked. And she said many people left because of the incentive created by those tools. Anyone who had their account frozen, Freeland said, had due warning. When asked, but what about the families impacted by joint accounts being frozen? They didn't have due warning. Minister Freeland replied that it was impossible to avoid that. And if joint accounts were frozen, there was an easy remedy: leave. And if the person engaging in illegal protest left, their account would be unfrozen right away. So let me know what you think of Minister Freeland's testimony. I think she's going to get some flack for it today. I do not think she did a very good job. I think she was one of the most political of all the ministers that we've seen testify so far. So let me know what you think. If you disagree, if you agree, I'm always interested to hear what you guys think. So next up was the panel from the Prime Minister's office. This summary won't be as long. I know I spent a lot of time on what Minister Freeland said, but this one won't be quite as long, or even half as long. So the Prime Minister's office witnesses included his Chief of Staff, Katie Telford, the Deputy Chief of Staff, Brian Clow, and the Director of Policy, a man named John Broadhead. These three witnesses were selected from the Prime Minister's office, not just because of their seniority, although they are very senior PMO staff, and Katie, I think, would be the most senior, but they were selected because they were all involved in advising the Prime Minister about the Convoy and Emergencies Act issue. The examination in chief by the Commission Council didn't have a ton of standout moments for me. One thing I thought was interesting was that the Commission lawyer put to the panel that the government did not have any actual evidence of foreign funding for the convoy. This had been put to Freeland as well. And certainly there was no evidence ever of any foreign state funding. Brian Clow for the panel admitted that there was never any evidence of foreign state funding, but he said it was clear to the government that there were some individual foreign donations because the political commentary in the United States was taking place. And he said the issue isn't the foreigners can't comment on things happening in Canada, is that they were supporting unlawful activities, including border blockages. The panel was asked about the incident response group as well. This is the cabinet committee that we know almost nothing about. We did not know about this committee really until the Emergencies Act was invoked. Katie Telford said that they decided to convene the incident response group, the IRG, because meetings had become more and more frequent about this convoy issue, and they decided it was time to formalize the structure. She said that they were at the stage of a national crisis, so they convened the IRG, which is chaired by the Prime Minister and has no set members. And she said the IRG is meant to deal with real-time crises, and unlike cabinet meetings, IRG meetings have officials sitting at the table with cabinet ministers, a select group of cabinet ministers, and they are actually the principal presenters. The panel was also asked about engagement or lack thereof with the protesters, and the commission lawyer pulled up a text that had been sent to Katie Telford with the name of a possible mediator who had been recommended by former Justice Minister Anne McClellan. Katie said Anne was trying to be helpful and that many MPs had been raising names for potential mediators or arbitrators, and even MPs from other parties were trying to help. But Katie said no one could figure out who to talk to among the protesters because there was no clear leadership in the convoy. She also said there's a difference between mediating and engaging, and that the Prime Minister was not prepared to negotiate on what she said were public health measures rooted in science. She said ultimately the government didn't engage because there wasn't enough of clarity about who they'd be talking to or what they'd be talking about. Now, I'm not sure what I think about this since obviously we know from the evidence so far that the municipal government had made moves to engage with the protesters, and this was actually being encouraged by the federal government. Earlier evidence from the inquiry actually included text messages from, I think it might have been the mayor's chief of staff to Mayor Watson's chief of staff to federal political staff at Mendocino's office, saying how absurd it was that the federal government was encouraging the city to negotiate with the protesters while the feds were publicly disparaging the protesters as radicals and racist and all that. The Commission Council also asked the panel about rumors that probably most of us have heard about the timing of the revocation of the emergency, specifically this rumor that the emergency declaration was revoked because it was going to fail a Senate vote. So Brian Clow responded that it was actually quite the opposite, that they'd been pushing the Senate to confirm quickly, but that they were delayed because there was difficulty getting some senators to Ottawa for the vote because of the convoy. Clow said he has no reason to think the Senate wasn't going to confirm, and he said that the Senate lead for the government was counting votes and was confident that they had them. Katie Telford also joined in to say that the Prime Minister actually revoked the emergency because he had promised not to use it for more than a minute longer than was necessary. I guess we're never going to know the answer. That's the answer they've given. We have no way of finding out what would have happened otherwise. But I certainly do believe that the government was trying to rush the vote. I believe that part. Sorry, guys. The convoy organizers also came up to do a cross-examination, and convoy counsel started by raising his ongoing concern, which he's raised throughout, which is a concern that I share related to the late disclosure of documents and inappropriate redactions. I won't get too much into it, but there have been a lot of what seem to be improper claims of privilege, and this makes cross-examining witnesses a big challenge when we don't have all the information, or when we get access to that information after the relevant witness has finished testifying. So we don't have another opportunity to examine them. Miller asked the PMO panel when the first time the government publicly spoke about invoking the Emergencies Act was, and Katie Telford replied that ministers had spoken about it in media in response to questions before it was invoked in response to the Freedom Convoy, and that the government had actually discussed using the Emergencies Act early on in the pandemic to declare a public welfare emergency, and that they ultimately decided against it. Miller pulled up a note from another PMO staffer that we've seen before. It was from February 4th, and it said Katie Telford's cell, and had a note that said Blair's current plan EA, or Emergencies Act. But Katie, this was from February 4th, so planning to use the Emergencies Act that early is obviously quite early and definitely would not have exhausted legal tools. But Katie said these were not her notes, so she couldn't speak to them. But obviously, the 4th would have been quite early if that was actually the plan. So this should come as no surprise, but my favorite cross-examination was ours. It was conducted by Janani Shanmugathanan, and it's related to this legal opinion issue that we've heard so much about. A number of witnesses now, including CSIS Director David Vigneault on Monday and Minister Freeland today, have talked about this legal opinion that they have obtained that said the definition of national security threat in the Emergencies Act is wider than the definition of national security threat in the CSIS Act, even though the text of the Emergencies Act says that they're the same, and CSIS says that their threshold wasn't met. So this has been a big issue throughout. So Janani led a line of questioning to determine if cabinet received this information and if they received other relevant information that they would have needed in order to make an informed decision to invoke the Emergencies Act. First, we confirmed that the agenda for cabinet is ultimately set by the Prime Minister, and what information and documents are provided to cabinet is also ultimately up to the Prime Minister. Now, while it gets input and drafting from the Privy Council office and confirmed and input from the Prime Minister's office, Katie Telford confirmed ultimately it's up to the Prime Minister. So Jenny asked, was the CSIS assessment, the statement by CSIS that their threshold wasn't met, was that given to cabinet? We had earlier asked the clerk of the Privy Council office if it was given to cabinet, and she says she doesn't know. She doesn't know if cabinet received it, which means they probably didn't. Well, Katie also said she doesn't know if cabinet was informed that CSIS didn't believe there was a national security threat under their law. Next, Jenny asked, was a different threat assessment provided to cabinet? Again, the PMO panel didn't know. So then the big question, did cabinet receive the legal opinion that the Emergencies Act has a different standard from the CSIS Act? This is all just so important. Cabinet is not a rubber stamp. There's supposed to be debate within cabinet, and they're supposed to have all of the relevant information in order to have that debate. They need to debate within the need for this debate within cabinet is the whole reason that we have laws protecting cabinet confidence. And the decision that cabinet was being asked to make here was a very, very serious one. And it was based on a novel and probably wrong legal theory. So cabinet should have had the legal opinion and the CSIS opinion. And we know they didn't have the CSIS opinion because Katie Telford doesn't remember giving it to them, and the clerk of the Privy Council doesn't remember if they received it. So did they have the government legal opinion so they could read it and come to their own conclusion about it? That's the question Jenny put to the PMO panel, the people who are responsible for helping put together and finalize the documents and agenda for cabinet. So then when she asked this question, did they get the legal opinion? The panel on their own objected and claimed cabinet privilege. They said, we can't answer that. It's a cabinet confidence issue. It's a solicitor client privilege issue. Now, Jenny wasn't asking for the content of the opinion, just whether it was given to cabinet, which is not subject to privilege, either cabinet privilege or solicitor client privilege. So Jenny responded, I don't see your lawyers objecting. So then the government lawyer interjected to say they can't provide information about the content of the opinion, but they can testify about whether or not the opinion was given to cabinet. So she got to ask her question, despite the panel objecting on their own, giving their own legal objections to testifying, which was bizarre. So she asked them, did they receive the legal opinion? Katie Telford said that she doesn't remember, but she knows that there were discussions about the threshold of the act being met. So I guess someone went in and told them, oh, we got a legal opinion, but we're not giving it to you. And then Brian Clough said they also talked about how terrifying Ottawa was at the time. That was the main focus of the cabinet discussion. So great. Cabinet wasn't informed, and they just sat around talking about how scary it was to be in Ottawa. And they weren't provided with the CSIS threat assessment, and that said that there was no national security threat and that the standard wasn't met. And then they voted to invoke the act without knowing the legal theory that they were basing their decision on. Completely negligent. And this is on the Prime Minister, the PMO, and the Privy Council office, who are responsible for making sure that cabinet is informed. Okay, I know I'm pretty worked up about this, but that was a amazing cross-examination that we had today, and I'm just very disturbed by everything we've been learning at this commission. Tomorrow is the big finale. It's the Prime Minister testifying in the morning. I'm going to get there really early to make sure I get a good seat, and I think it's going to be jam-packed. And to the people who came up to say hi to me today at the inquiry, thanks for coming to say hi. It was nice to meet you. If you're there tomorrow, come and say hi to me as well. And if you liked the video, if you liked all of these videos, please subscribe to my channel. And for those of you who have said that you're going to miss me when this is all over, don't worry. We have many more cases fighting for fundamental freedoms in Canada. Well, actually, I guess that means you probably should worry. But our fight is not just limited to this issue. There's so much more work that we are doing making Canada a freer country. Okay, that's all for this. Thanks, everybody, and have a great night.